And welcome back here to Live Now from Fox. I'm Andrew Kraft. Thanks for being with us here. Let's keep it moving with more of these top headlines. We're going back to the Supreme Court right now. A pretty bizarre and weird headline today, courtesy of Bloomberg. They first noticed this, that SCOTUS inadvertently released its opinion in EMTALA abortion case earlier this morning. The justices are poised to allow emergency abortions in Idaho, suggesting the court shouldn't have gotten involved in the early litigation. Just some more video on this story and some more details on it as well here. This is what we know. The Supreme Court appears poised to allow emergency abortions in Idaho when a pregnant patient's health is at serious risk. That was according to Bloomberg News. They were the first to report this, which said a copy of the opinion was briefly posted today on the court's website. The document suggests the court will conclude that it should not have gotten involved in the case so quickly and will reinstate a lower court order that had allowed hospitals in the state to perform emergency abortions to protect a pregnant patient's health there. Let's talk about the case in question, but also the inadvertent publication of it with our friend there at the Heritage Foundation, Sarah Perry. She joins me. Sarah, good to see you here. We spoke earlier this week on a case the Supreme Court is going to take up next session there on transgender rights. This one, though, on abortion. Let's talk about the case itself here. So in a state like Idaho that restricts abortions quite stringently here, this federal law now allows for, according to the ruling that we're not going to get yet, we're going to get soon, it allows for abortions to happen if there is a medical emergency with the patient. Is that how you read this?
Well, that's pretty close. In fact, this particular circumstance right here, we're dealing with the interpretation of a federal law that's being read by the Biden administration a particular way. And they're using that reading to essentially say that their reading trumps longstanding state law, and specifically more recently, the Idaho Defense of Life Act, which prevents all abortions except if necessary to protect the life of the mother, and in cases of rape and incest. Well, the definition does conflict with EMTALA's current reading that abortions can be provided for the health of the mother. So when health conflicts with preserving life only, the United States Department of Justice has argued that their reading should trump under the Constitution's Supremacy Clause. But this positioning here was actually a procedural punt. It was dismissed as improvidently granted. If what we see tomorrow is exactly what we saw today, or close procedurally, a dig order, as it's commonly known in legal parlance, essentially means that the court has decided they're not going to make a determination at all, that they granted review, and for one reason or another, either a procedural reason or a substantive legal reason, decided that it wasn't in the best position to be considered by the court. That's what's happened here. So they're saying essentially all of the justices in one way or another, except Justice Alito, who writes a fairly fiery dissent that's joined by Justice Gorsuch in most parts and Justice Thomas in its totality, essentially says this is an opportunity, a golden opportunity to clarify the federal government's reading of this law. And essentially you've squandered that opportunity. But it goes back now, if again, this is what we see tomorrow, to the Ninth Circuit for continued litigation.
Okay, so yeah, you're right. The case would continue at the Ninth U.S. Circuit Court of Appeals. Presumably from the ruling we saw today, they're just going to kick it back down to the lower courts. All right, but my question is, from the ruling we saw today to whenever it is officially released, can it be changed in the interim? According to the Associated Press, the finding may not be the court's final ruling because the justice's decision has not been officially released. So whatever was inadvertently publicized today, that might not be the final ruling?
Yes, that's exactly it. In fact, we saw, obviously, with the Dobbs leak 2 years ago that came from Politico, we saw the ultimate opinion, almost word for word copy what was originally leaked. That isn't essentially legally required, and it may not be the case here. In fact, until it's formally announced, which will involve probably a reading from the bench and publication on the official Supreme Court website. They're wholly within their authority to change, reorient, reorder, or make any other modification they want to. It's not considered a formal decision by the Supreme Court until it's formally published by the court itself.
I see. Okay, this is how the court is responding to this today. Patricia McCabe, she's a spokeswoman for the court. She says this, quote, the court's publications unit inadvertently and briefly uploaded a document to the court's website. The court's opinion in Moyle v. United States and Idaho v. United States will be issued in due course here. You know, I think it's a good opportunity to kind of flesh out some of the questions I know so many viewers have about the workings of the Supreme Court here. You know, from what I understand, and correct me if I'm wrong, all of these rulings on all of these big questions, they're already done, right? We're just waiting for them to be officially released by the court. It's not like the 9 justices are, as we speak, in their chambers furiously writing their opinions, right? It's largely over.
Right. That's exactly correct. And while we anticipate that we'll see the remaining opinions by the end of this week, there are only 10 left. It wouldn't be unheard of to actually eke out into the first week of July. It has happened before, though it's not generally sort of the manner in which they do things. But yes, at this point, everything should be written, although there is always the opportunity until it's published to make whatever changes the justices see fit.
I see. Yeah. And extending into July is quite rare for the court. That maybe goes to show you, you know, how significant some of these questions before them are that they have to grapple with here. What about the court itself? You know, it's at hands of its critics been accused of being this opaque branch of government that we don't get to see. Yes, we can hear the arguments in audio transcripts. Should they be more transparent when something like this happens, this inadvertent publication today? Should we know more about the Supreme Court as American news consumers, American citizens, when something like this happens, too? It just leaves more questions than answers. Would you agree?
Yeah, I think there will be, and I would not be surprised if we see this in the next coming days, a statement from the Chief Justice indicating exactly what happened or how it happened. I think there was certainly some damage control inside the actual court itself, and the publication from the public information officer saying that this was an inadvertent error and it was immediately taken down is probably the best possible approach in what is ultimately, I think, just a continued sort of diminution in the status of the Supreme Court. We saw that with the Dobbs leak. We saw it now with the secret reporting of Justice Alito. These seem to be sort of ironically timed with some of the bigger decisions, and especially so when it considers the issue of abortion. So I have to ask whether or not there's something rotten in Denmark, but I think more transparency from the court, more public-facing commentary on what happened, more sort of commentary on whether or not this is an ongoing problem or whether or not it truly was an error of the publication button, which, as we all know, with a number of opinions that have been released in very short order, long opinions, it's always possible that something like that can happen.
Yeah, that's so right. I mean, it could have just been an honest mistake or a grave error. And it is so coincidental that the high-profile leak in May of 2022 of this Dobbs decision draft, and now this one here, both having to do, of course, with the very highly contentious issue of abortion. So we'll just have to see on that. Is the court facing somewhat of an institutional crisis to its legitimacy at the moment since that leak of the Dobbs draft decision here? And you have this story today. It seems like they can't catch a break.
That's actually a great way to position it. Again, there does seem, I'll just sort of paraphrase the Bard and saying that there's something seems to be rotten within the Supreme Court itself. I don't find it coincidental that now we are looking at an inadvertent publication once again on the issue of abortion. And it's very interesting to me that justices sort of excoriating dissent in this pre-released dig order says explicitly, listen, you're punting on a highly politically charged issue, but it's an easy case to resolve. The government's argument on standing and whether or not the preemption of their reading over state law prevails is really unsupported by the legal analysis. But I do think that there have been a number of specific directed attacks at the institution's legitimacy. I don't think necessarily it is that the institution itself is any less legitimate. In fact, we've seen a number of unanimous opinions, and we've actually seen some surprising opinions that many believed were going to come out sort of with a bent toward the right. I think we were surprised by the FDA case. This is another surprise
This
as
one,
the
yeah.
Dig order and the EMTALA case here. I think the Murphy versus Missouri case that came out today was
Yeah.
also substantively surprising for many of us. So I don't think that the court itself has a problem, but I don't think there are any shortage of individuals ideologically progressive, liberal, or centrist that probably have issues with how the court in the past has ruled on some of these highly charged political cases.
All right, Sarah Perry, we're going to have to leave it at that. We do appreciate your insight into the High Court and its rulings and forthcoming rulings today as well. Thanks so much.